And well, amid all the social upheaval stateside this week, the US Supreme Court, in a surprise 6-3 decision, confirming federal law prohibits discrimination based on sex, but expanding this meaning, I guess, to include sexual orientation and gender identity, in a major win for LGBT workers and their allies. People and Culture founder and workplace expert Joydeep Hor joins us live from Sydney for more on this. Joydeep, pleasure to have you on the program. I guess let's just talk about this in relation to Australian laws, because Australian law is quite similar to the US in this area.
Yeah, it's really interesting. We often look at America as a place of great rights and liberties and Declaration of Independence and all of the things that Australian citizens know probably as well as Americans do. But quite remarkably, Australian anti-discrimination laws, particularly in an employment context, are more sophisticated than the laws that are in place in America, even though the US has had legislation and rights for much longer than Australia does. What this case has highlighted is that I think a lot of people here in Australia would have been quite surprised that that there's such a big deal being made in the US about a decision that says, look, you can't be discriminated against in employment on the grounds of sexuality. Here in Australia, we have had laws dealing with that for quite some time. But it's interesting how the timing of this decision really couldn't have been more apposite in terms of what's going on in the US and globally in terms of Black Lives Matter and other things.
No, absolutely. There's so much movement towards anti-discrimination across the world right now. But given that we're living under effectively a COVID overhang right now, do you think people are going to, and businesses, are they going to be able to focus on this new aspect in the US and here, of course, in Australia, when there are so many rules about navigating simply through this COVID period?
Yeah, I think that the reminder for employers at all times, and I see this happen regularly. Employers, you talk to them about discrimination and everyone looks at that through a very binary lens. They think, well, discrimination's very obvious. Discrimination, as if we would do it, as if we would not hire someone because they're pregnant, or as if we would not hire someone because of their racial background. And people look at a very specific type of behaviour or specific types of behaviour as being the watch-outs. What they forget is that the real issues in an Australian employment context are what we refer to as indirect discrimination. And it's when employers introduce rules and policies and conditions in their organisations, and they make those rules and conditions and policies applicable to everyone. But when you look at, even though on the face of it, it doesn't seem like anyone's being differentially treated because the rule has nothing to do with a person's race or age or whatever it might be. When you look at the people who can or can't comply with that particular rule, what you see is that it has a disparate impact depending on person's characteristics. And your question, Daniel, is a really good one when it comes to the current circumstances of COVID, because a lot of employers are saying, well, look, we just want to introduce some blanket rules and policies that apply to all of our people in our organisation. For example, we want to say everyone has to come back into the workplace. And what that's going to be a risk for employers in relation to is you're not directly discriminating against anyone, but in the current circumstances, there could be any number of groups who you're indirectly discriminating against. For example, people who might have carers' responsibilities for young children, people who might have a relative or family member who has been diagnosed with COVID. There are a whole heap of things. Employers need to be really careful about this. And I think one of the real thematic issues at the moment is that there has been, in the last few weeks, and there will continue to be, a far greater narrative around what constitutes discrimination and people willing to take the argument to employers because of a groundswell of momentum in this area.
Yeah, it's such a big time for that. And as you say, it's case by case, a very individual thing. But I guess, are there any general suggestions for employees to not only minimise their risk in the space, but also just to do better?
I think employers need to be very clear about what policies they have in place. They need to understand that the best way that you can manage your risk in this particular space is create an environment and culture where people feel that they can talk to you about matters that are concerning them, and that they don't feel that their only way of getting attention or getting listened to or having a problem dealt with is by going down a legal path. And the organisations who invest the time and energy in getting that cultural piece right will unsurprisingly be on the right side of the legal ledger as well.
What sort of recourse do workers have then if they are feeling discriminated against? Is it a discussion? What should workers do, Joydeep?
The flip side of it for employees is absolutely try to deal with these matters as soon as they arise in a constructive way. Be clear on the outcome that you as the worker or employee are seeking. If you feel that you're not getting the necessary traction from your employer, from the Human Resources Department or a senior leader, then there are external avenues available, the Human Rights Commission or the Anti-Discrimination Board, depending on where in Australia you are. But if you're going to go down that path, you do have to be prepared for a level of acrimony. It's expensive, it's time-consuming, and it's unlikely to end well for anyone. It's certainly been my experience.
All right, Joydeep, always a pleasure and some great insights there. Thank you very much for joining us on the program.
Thank you.